It's very important that you understand how these recent Supreme Court decisions impact your right to keep and bear arms, even when those Supreme Court decisions don't specifically talk about the Second Amendment. This is another example involving the Chevron Doctrine, which is no more. As you know, the Chevron Doctrine says that judges have to defer to the interpretations of law set forth by the administrative agencies, such as, for example, the ATF. Now, this Chevron Doctrine is now gone, thank God, but I want to talk about this Vanderstock case dealing with partially completed frames and receivers or weapon parts kits, the so-called Ghost Gun Supreme Court case, and I want to give you some examples from the Department of Justice brief just filed in the Supreme Court about how the DOJ and the ATF likes to cite as authority to, ready for this folks, themselves. Wait till you see what I found in this DOJ ATF brief to the U.S. Supreme Court in the Vanderstock Ghost Gun case when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attacks Teach Americans About the Right to Bear Arms. A lot of critically important historical and contemporary information in Israel Disarmed that we in the United States can benefit from, learning about the importance of armed citizens and what happens when you don't appreciate and effectuate an armed citizenry. The lessons that the Israelis should have learned after World War II, but apparently failed to learn those critical lessons, came back and unfortunately ended in tragedy on 10/7/2023. I break it down for you in detail. Check out the book on Amazon, Israel Disarmed. Okay, folks, as you know, we've talked quite a bit about the U.S. Supreme Court decision in the Loper-Bright, sometimes referred to as the Relentless case, that said that the Chevron Doctrine of deferring to the legal interpretations of administrative agencies is no more. Specifically, the U.S. Supreme Court in the Loper-Bright case said that the longstanding doctrine known as the Chevron Doctrine is no longer the law of the United States, and that federal courts no longer have to defer to the legal interpretations of regulations or whatnot of the administrative agencies that have the authority to regulate in a particular area. So you no longer have to defer, meaning a federal judge no longer has to defer to the SEC's interpretations involving securities laws. They don't have to defer to the ATS rules involving firearms laws, and so on and so on. The court is supposed to figure out what is the right legal answer and then apply it, because as you know, the basic structure of our government is that the Congress enacts the laws, the president and the executive branch enforce those laws, and the courts are supposed to interpret those laws. And when you allow executive branch administrative agencies to be able to decide what the law means, that courts have to defer, you have a separation of powers problem, where you're basically saying that the president, who's responsible for enforcing those laws, also gets to interpret those laws and tell you what they mean. An absurd violation of the separation of powers, which Chief Justice John Roberts and the rest of the Supreme Court understood in the Loper-Bright case when they said the Chevron Doctrine is no more because it violated the separation of powers doctrine by and among the three branches. Now, with that said, I want to use this case that is now pending before the Supreme Court that we're all going to talk a lot about between now and next year. That is the Vanderstock case, Vanderstock versus Garland. It is the quote-unquote ghost gun case. This involves the attempt by the ATF through reinterpretation and rewriting of regulations to expand the scope of their powers to not only regulate firearms, but to expand the definition of firearms so greatly to include parts kits involving parts that you use for firearms, or not just frames and receivers, which is in the statute, but now partially completed frames and partially completed receivers all of a sudden become firearms too. As to what that means, who knows? That's up to the ATF to determine whether or not you violated it and then put you in prison if they think you did. But because, of course, the Supreme Court has said you no longer have to defer to the ATF or these agencies, that is a huge benefit. Nevertheless, I want to teach you and show you in the submission that was just made in the last few days by the Biden administration, by the Joe Biden administration, the Department of Justice, the ATF, their submission to the United States Supreme Court, just to see how basically the ATF and DOJ relies upon themselves for legal authority. It'd be analogous, and you're going to see, I'm going to read you the language, and you're going to see exactly what I'm talking about. Basically, it's like saying, I, Mark Smith, am the smartest person in the world, and here's an article by Mark Smith that says I'm the smartest person in the world, and I get to cite to that article by Mark Smith about Mark Smith, and lo and behold, it says exactly what I wanted to say. Now, that's absurd, of course, right? But here you have, and you're going to see, the ATF is literally engaging in this where they're citing as authority themselves. Think about that. The legal authority to justify what they're doing is dependent entirely upon the citation and relies upon their own proclamations. How convenient. Nevertheless, this is exactly what ATF does. Let's go to the highlight reel, and I'll show you. And again, this is literally what they submitted last week in the United States Supreme Court in a pending case of Vanderstock, trying to justify the expansion of ATF authority over the gun industry and the Second Amendment. Let's check it out. So the first statement made by the ATF goes like this, quote, responding to that concern about the alleged rise of ghost guns, and, quote, consistent with ATF's longstanding interpretation and implementation of the Gun Control Act. So did you see that language? So here you have in the legal brief, the ATF is relying on ATF's longstanding interpretation of the Gun Control Act. So the first legal authority that they talk about is literally their own interpretation. Isn't that convenient? Hey, you can believe me. You know it's right because that's what we said is right, and we've been saying that for a long time, so you must trust us. So that's the first example of them relying upon for authority themselves. Very convenient. Now, let's go to a next point. Next example of this in the same brief in Vanderstock. The second example of the ATF DOJ saying, hey, defer to me, trust me, can be found on pages 5 and 6 of the DOJ brief in Vanderstock. This is what they write. Although the 1968 regulations did not explicitly address the issue, ATF has long held that a frame or receiver need not be complete or functional in order to qualify as a frame or receiver under the Act. And what do they cite to? Federal, guess what? 87 Fed Reg at 24,685. Well, the Federal Register is what? Oh yeah, that would literally be the ATF's regulation promulgated by the ATF. So here you have the ATF again citing to the ATF for authority to justify what the ATF is doing today. But again, what else is the ATF talking about? Oh yeah, they say, hey, trust us because we've been doing this thing wrongly, in my view, for a long period of time. Check out what they write next in the brief about, hey, trust us, we're the experts, long-standing policy. Our policy, of course, isn't that convenient? Check it out. That approach is reflected in dozens of classification letters issued over the past half century. For example, ATF has consistently found that partially complete frames qualify as firearms if they can be readily converted to functional condition, citing to a 1978 letter from, guess what, the ATF. Or if they are basically complete and require only a small amount of machining to attain functionality, citing to, among other things, other ATF letters. Isn't that convenient, citing to ATF letters? But let's carry on. But let's see what else the ATF relies upon. Oh yeah, they rely upon the ATF to make their argument that the ATF is right. Check out this next one. The DOJ writes on behalf of the ATF as follows, quote, ATF has long considered the length of time necessary to complete a frame or receiver in making classification determinations. In 1980, for example, ATF explained that an unfinished receiver would likely qualify as a firearm if it could be converted to functional condition within a few hours using common hand tools. And ATF has accordingly classified such items as firearms. For example, citing to the petition, receiver that required approximately 75 minutes of work to become functional, receiver that took 75 minutes to complete using common tools, and considering whether a partially complete receiver could be completed. And again, here you have the ATF relying on ATF letters written by ATF to justify today's ATF position. How convenient, right? This is what they've been doing. This is what every administrative agency in the federal government has been doing. They make stuff up. Then down the road, they say, we made stuff up a long time ago. Trust us, rely upon it. And then they just sort of basically rely on their own precedents that they designed initially. This is what the ATF is doing, as best I can tell, in Vanderstock as well. Now let's go on to the next example of the ATF relying upon ATF to justify their interpretation. So the ATF argues that, quote, the new rule, right, about frames and receivers, the new rule clarifies that the undefined terms frame and receiver in the Act's definition of firearm include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed to and may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. And they cite to the CFR provision in the regulations. But here's the best part. Then ATF goes on to cite as authority themselves. Check it out. ATF noted that it had long interpreted the Act. ATF noted that it had long interpreted the Act to cover partially complete or non-functional frames and receivers that can be made functional using basic tools in a reasonable amount of time, citing to their own regulation. Their own regulation. Again, another example of the ATF saying, trust us, cite to me. I'm going to cite to me. Again, Mark Smith is the greatest thing ever. I'm going to cite to an article by Mark Smith about Mark Smith. That's very convenient. It's like the ATF relying on ATF information about the ATF and what they've been doing. Crazy, crazy. This is the sort of thing we see all the time with these agencies. Now, the next thing is the next example of this, where, again, they say, this is what we've always done. Trust us. We're the experts. And the ATF writes that, quote, ghost guns were attractive to criminals, minors, and others who were legally prohibited from buying firearms. Responding to that concern and consistent, ding, 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 and consistent with ATF's long-standing interpretation and implementation of the Gun Control Act of 1968. You hear that? Consistent with ATF's long-standing interpretation and implementation, as if the ATF's long-standing interpretation and understand the Gun Control Act has any bearing on anything. Again, the ATF is relying upon themselves for their legal authority. Very convenient, once again. And again, another example of the ATF citing to themselves is found on page 5 of the brief. It says, although the 1968 regulations did not explicitly address the issue, ATF has long held that a frame or receiver need not be complete or functional in order to qualify as a frame or receiver under the Federal Act, citing to, again, the ATF's Federal Registrar of the regulations. So here we have another example where the ATF is trying to tell the Supreme Court, we have this right under the law because it's what we, the ATF, have always done, and we can do no wrong. That's the absurdity of these federal agencies. They rely upon their own precedents. Super convenient, isn't it? And just to look at the chutzpah of the ATF, their argument here goes on to say that the reason why the United States Court of Appeals for the Fifth Circuit got it wrong is because they didn't rely upon the ATF's historical practice of, in my view, misinterpreting the Gun Control Act of 1968 and more. Here's what they say against the Fifth Circuit in their brief to the Supreme Court here. In reaching a contrary conclusion, the Fifth Circuit failed to meaningfully engage with the Act's text and, ready? Bing, 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 bing. And wrongfully dismissed ATF's consistent practice. Oh, woe is me. I'm so sorry, ATF, that the United States Court of Appeals, with federal judges who are expert in interpreting the law, did not give you enough credit. They didn't defer to you enough. Well, guess what? They don't have to defer to you for a whole host of reasons, not least of which is the destruction of the Chevron doctrine. But thank you for telling us what you think is the law today based upon what you've been doing all these years. And to close this out, yet again, at the end of the brief on page 37, again, they rely upon their long-standing practice. That's like saying, hey, I've been eating cookies my whole life, so therefore I'm allowed to eat cookies because that's all I am ever allowed to do, and I'm going to rely on that practice that I'm the one that created. Here's what the ATF says toward the end of their brief to the Supreme Court in Vanderstock. Quote, ATF has consistently considered the length of time necessary to complete a functional frame or receiver when making classifications, and has repeatedly considered whether standard hand tools can be used to readily bring a partially complete frame or receiver to a functional state. The rule is thus consistent with, hear what I just said, is thus consistent with ATF's longstanding approach to the Act's definition of frame or receiver. So yet again, the ATF's argument in the year of our Lord 2024 to justify what they're doing to try to expand their authority to cover quote-unquote ghost guns, which is really just gun parts, right? They want these gun parts to be serialized, and they want people that sell these to not just serialize them, they want to force them to keep records and to do background checks to make sure that they know who out there has these unserialized guns, which will no longer be unserialized because they'll now have a serial number associated with them, and your name will be connected to that serial number, which is really a form of gun registry. We can talk about that in a separate video. But the point is, I wanted to give you these examples just so you can understand how the game is played. Historically, these agencies like the ATF do stupid crap, in my opinion, and then they rely upon the stupid crap they've done in the past to say, hey, this stupid crap we're doing today is entirely consistent with the prior precedent of the stupid crap we've done in the past, and therefore today's stupid crap is legally justified because of the stupid crap we've done in the past, and now we have these precedents. But I'm happy to report, because of the destruction of the Chevron doctrine, the federal courts don't have to give any deference whatsoever to what the agencies have been doing. They're allowed to consider it if the agencies have acted in a particular way, basically contemporaneously with the enactment of a statute. There's some authority for that specifically, which is not what the ATF's talking about here. But the fact that the ATF did something right or wrong for the last many decades has no bearing on whether or not their interpretation of the law today is correct. Nevertheless, you see the Department of Justice with Joe Biden, the entire reliance, not the entire, but most of the reliance is basically saying that we, the ATF, are super smart. We have a concern. We're allowed to act. It's consistent with our legal authority, and it's consistent with what we've always done. Of course, what they've always done may or may not be lawful, may or may not be right. So we will see what the Supreme Court does. We're going to cover the Vanderstock case a lot more as things progress, but I did want to bring to your attention just how this game gets played by the Department of Justice and why the destruction of the Chevron doctrine may potentially be super helpful for preserving freedom here in the United States. All right, folks, so there you have it. I hope you follow me here on YouTube. Don't forget to follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.